All right, Bad M307 students, finally some new material. The first new material that we're going to take, other than the updates, a couple of which we've already covered, is the discharge of contracts. Now, there is no chapter number because I don't get into that in my textbook for risky business, because that was designed actually for BADM 107. It's substantially helpful for BADM 307, but there are a couple of topics that aren't covered in there, and one of them is our new material, discharge of contracts. So what I will do is I will photocopy some material out of another textbook and scan it and put it online, and we are allowed to do that. Now, we've done intellectual property, so you know that that could be considered copyright infringement, but apparently for educational purposes you're allowed to use one or two chapters out of a textbook without actually infringing copyright. So that's what we'll do. I'll get that online. You can read it if you need some additional explanation of the material. Now, a discharge of contract is to cancel the obligation of a contract or to make a contractual agreement null and void. There are four ways that this can happen. The first and most straightforward is by performance, then there's by agreement, then there's by frustration, and yeah, you're feeling frustrated right now, I'm sure, but that's not what we're talking about. Bringing a contract to end by frustration at law. And then the fourth way is by operation of law. So we are on slide 97, and we'll go through each one of those in turn. Not too much to be said about contracts coming to an end by performance, because most contracts, this is what happens. You agree to buy a quart of milk, you get the quart of milk, you drink the quart of milk, you pay for the quart of milk, and bingo, the contract is discharged by performance. However, there are a couple of problems that can crop up, and the first is that the party that is paying under the contract is under an obligation at law to tender performance. Tender performance, what's that mean? Well, it means you must tender performance exactly as specified in the contract. So if I say, I'll sell you my car for $7,000, and you say, great, I'll buy it, and I say, okay, I'll meet you at 5 o'clock in the parking lot at Capilano University, I'll bring the transfer payments, you bring $5,000, and okay, and then we meet, and I said, okay, I've got the transfer payments, I'm going to sign them, where's my money? And you hand me a check. And I go, sorry, no, I'm not selling to you. And you go, no, but I'm here, I'm tendering performance. And I go, no, you're not. You're giving me a check, and I said $5,000 cash. And you go, no, this is as good as cash, and I'll get it certified. Well, even a certified check isn't cash. So I could, if I wanted to, back out of that contract and have it discharged because you failed to tender performance. So that's one way that tender performance can be a problem. The other is you have to seek out the party, okay, in certain circumstances. For example, under a lease, if you're a tenant, the term of the lease is you have to pay the landlord. So you cannot sit in your premises and wait for the landlord to come to you to pay him or her. What you have to do is you actually have to seek out the tenant or the landlord and pay. And there have been situations where the landlord, after signing the lease and allowing the person to move in, wanted the premises back. But you can't, because it's a contract. You can't just cancel it unless there's a term providing for it, and we'll get into that later. So what happened was the tenant at the end of the month said, well, the landlord didn't come by for the rent check, and and kept operating, and landlord didn't come by. A few days go by, and the tenant comes in the next morning, and there's a lock on the door. And the landlord was successful in saying that he had forfeited the lease because he did not tender performance in accordance with the law. So you have to seek out your creditor. Okay, if you owe money to someone, you have to seek out your creditor. Tendering performance can also occur in another way. There was someone at the university who asked me to purchase, act for them in the purchase of a condominium at Whistler. And I said sure, and regretted it afterwards. I gave them a set price of what it was going to cost based on sort of the standard conveyance. And it turned out that the person I was acting for was getting a really good deal. And the reason they're getting a really good deal was the person that was selling the condominium was in debt, like terribly, terribly in debt. There were 3 mortgages and a tax sale notice on the property. So in other words, I am going to send the money to the lawyer on the other side, and it's the lawyer's duty to then send me a certificate of title free and clear of all charges for my client. The day of the transaction comes around, and I've got the money in my trust account, and the lawyer for the other side calls up and he says, Peter, I don't think we're going to be able to complete. And I knew him, and I said, oh, no, don't do this to me. And he said, no, I'm sorry, I don't think we're going to have enough money to pay off all the charges. So the lawyer was not going to accept my money because then he would be under an undertaking to give me clear title. So he said, well, we'll just have to wait and see. So what that meant was I had to take a solicitor's trust check for the purchase amount and go over to his office and sit there until 4 o'clock when the land title office closed. If he had not had his agent lodge the transfer documents before 4 o'clock, then it would not complete on that day. If I had sat in my office and said, well, I wonder if we're going to complete or not, and then at 5 o'clock he says, okay, I found the documents and it's completed, but you haven't sent me the money, I would fail to tender performance before the end of business on that day. So my client would be in default, the transaction would become null and void, and the deposit that my client had already paid as a down payment on the property would be forfeit to the owner. And I suspect the owner might have been trying to maneuver that without his lawyer's knowledge, because if he could possibly do that, then he'd get to keep the down payment, and then he'd have more money to pay off all those debts on the property. I don't know that, but I suspect that might be what happened. So I had to go over to this lawyer's office and literally sit there. And all this time, I'm not getting paid anything more by my client because I've given my client a quote, and I've already given him the purchaser's statement of adjustments, which shows how much I'm charging. And the lawyer was really nice. He came out and he gave me some coffee, and he actually had his staff go and buy me a donut because he knows I like donuts. And I sat there until 4 o'clock, and he said, okay, Peter, I'm sorry, we cannot complete. Or pardon me, I sat there until 5 o'clock, end of business. He said, I'm sorry, we can't complete. And so now my client would get the deposit back, but the vendor still wanted to make a deal, and so we lined up. He agreed to pay some amount more to get the transaction set down again, and I actually wound up sitting in that lawyer's office a second time because the vendor could still not get enough money to pay off all the charges on the property. It wasn't until the third time that the transaction finally completed and my client got the property up there. So you have to at all times be ready and willing to close or to tender performance, and it has to be in the manner prescribed by the contract. Now, we have this silly statute called the Bills of Exchange Act, which I think is pretty much by the boards now, because I don't think it's very applicable to very much. But in there, it says that legal tender is Canadian money, Canadian bank notes, okay, silver coins up to $10, nickels up to $5, and coppers up to 25 cents, pennies. well, they're no longer copper. Nickels are still nickel, I think, but silver coins, we don't have any silver coins. But it still says that in the Bills of Exchange Act. And it's just not worth anybody's while to go through the process of amending it, because it's become very irrelevant with the electronic transfers of cash and things like that. People don't pay in coins very much anymore. But if you went into a store and you said, I wanted to buy, that pair of shoes, and here's $60 in quarters, the vendor could refuse to accept that, and there's nothing you could do about it, because in effect it would be $10 is the maximum in coins you'd have to take. Okay, well, that's enough about performance. The next topic is discharge of contracts by agreement, and under this topic there are 5 ways that you can have agreement. And the first and sort of easiest to dispense with is waiver. Okay, so I said I'll sell you my car for $7,000, and you say I accept. And then you come to me and you go, oh, Peter, I'm really sorry, but look, I don't have $7,000. I thought I was going to have some financing come through, but it didn't. I can't afford to buy it. And I say, okay, well, we'll just discharge the contract. I don't care. I've got another buyer. That's fine. Don't worry about it. Okay, so this is called waiver. I waive my rights. I could say, hey, listen, we've got an agreement. I'm going to sue you. I'd have a hard time establishing damages if I turn around and sold my car again to somebody else for pretty much the same amount of money. But I can agree to waive my contractual rights. Okay. Now, the second way is accord and satisfaction. This is where I have let's make it more substantial. Okay, we have a business. Well, let's take that real estate transaction. If the other side said, look, I can't perform, my client could say, hey, listen, I'm going to sue you for specific performance. And if the person said, look, I can give you $1,000 if you'll just, agree to cancel the contract, then yes, I could accept the $1,000, and this would be called accord and satisfaction. You've given me some sort of monetary compensation for the fact that you would be in breach of your contract, and so I agree to have it discharged by accord and satisfaction. This is perfect, because then there's consideration for the discharge of the contract. If we go back to the waiver situation, there is a real danger here if you are in a lease situation. There have been lots of times when somebody's renting premises, business premises usually, and the rents are going up. Okay, rents per square foot, but I've got a 5-year lease. And I have 3 years remaining. So, wow, this is great. Except that I want to move. Okay, so I've got this 5-year lease, and I want to get out of it because I want to do something else. And the landlord would kind of like me to leave, because then instead of renting at $20 a square foot to me, he can rent it $25 a square foot to another tenant. So you say to the landlord, look, I want out. And it's to your benefit, because you'll be able to rent it at a higher amount. And if the landlord says, well, sure, and you go okay, and you shake on it, and you go your way, and he goes his way, and then the landlord finds he cannot get a tenant, you're in trouble, because this is an agreement for land in excess of 3 years, and all agreements with respect to land must be evidenced in writing. So he was willing to waive his right under the contract because he thought he was going to be able to rent it. But when he doesn't rent it, you're still bound to that contract. So what you want to do is get a surrender of lease. I'm writing that on the board. I really don't have to, because at the end of the course, we talk about landlord and tenant, and I talk about surrenders of lease again. But in case this comes up on the midterm exam, surrender of lease. And what you do there is you get it in writing, and you give it to him, and you sign saying you're leaving, and he signs saying he agrees to that, and now you're okay, right? No, you're not. You're not okay because you're getting consideration. You're getting out. That's what you want. What consideration is he getting? Well, he's not getting any rent. As a matter of fact, he's getting less than he's owed. So what you want to do, yes, a lot of you have thought of it already, you want to get that surrender of lease signed under seal. Okay, so you affix the seal at the time or before you sign that agreement. And that just reminds me of something that I should have talked about when I was talking about guarantees. Okay, I'll do it now. Remember back when I was talking about the Kiska case, the lessons learned from the Kiska case, and we listed off that, the seal has to be affixed at the time or before it's signed, and if the seal isn't there, then it's not binding unless the promisee can show that the promisor got some consideration. Those sorts of things. What happens in banking situations is when the bank wants you to sign a personal guarantee, they will not let you sign then and there, even with the seal affixed. What they will do is they will say, I'm giving you this document. You must go to a lawyer or a notary public and have your signature witnessed, and so that you have independent legal advice. Okay? ILA, independent legal advice. Oh, I'm going to write that in the board because you have to remember that. ILA, independent legal advice. Because if you go to your lawyer and you say, I don't understand what that little red dot is, and your lawyer explains that to you, then you go back and sign, and afterwards you go, hey, I didn't know what it was. Well, you had independent legal advice, so yes, you did. Okay, so anyway, accord and satisfaction, you're okay because there's some consideration going both ways. You're getting out of the contract, but you're giving some money to the other side to make them happy. Waiver, you can have an agreement waived, but it's it's safer to pay a nominal sum, $1. Okay, okay. Accord and satisfaction. The next one is novation, and novation means new, novo. Okay, new. So you're entering into a new agreement. So it can be a substitute agreement or there can be a material alteration of the terms. So substitute agreement. I have a client up north. He runs a lodge. He has a hangar, aircraft, does, flies people around fishing and canoeing and hiking and hunting. And people stay at the lodge. Part and parcel of the fact that he's on the Alaska Highway, way out in the middle of nowhere in northern BC, his business also has a gas station. Well, it was a corporation before they bought the lodge. Okay, and when they went to buy the lodge said, well, okay, yes, we'll sell the lodge to you, but you're going to have to take over this contract with, I believe it was Husky Oil. Because they provide the gas for the gas station. And so then there's this Husky Oil agreement with this lodge has to be changed. And a new agreement in substitution of that agreement must be given to the client purchasing the lodge. Okay, so that would be a situation where you're buying a business and it has existing contracts. Well, those contracts are still with that business. In order to make the transfer, there has to be a new substitute agreement, same terms and conditions, but between the Husky Oil and other suppliers and the new owners. Material alteration of the terms is where I have a number of cars for sale. Okay, I've got a Yaris, I've got a Caravan, I've got a Dodge Colt, and you want to buy the Dodge Colt from me for $7,000, and we enter into an agreement, and then as it turns out, the day before the transaction, a car goes off the road and slams into my Dodge Colt and destroys it, and so suddenly I've got a contract that I'm still bound to give you my car, and you're going to pay me for it, but you don't want what's left of the car. And so you can sue me because I'm supposed to give you a 1995 Mitsubishi Dodge Colt, and I'm unable to perform. So I go to you and I say, look, I tell you what, the Yaris is actually newer and better on gas, and what I'll do is we'll take out Mitsubishi Dodge Colt and we'll put in the Yaris. So instead of a new contract, a substitute agreement, what we do is we just materially alter the terms of the contract. Okay. So the next way that there can be a discharge by agreement is an option to terminate in the contract itself. And you should always consider options to terminate when you're entering into a contract. People rent houses all the time, and they say, "Oh, well, I just have to give 1 month's notice." Well, yeah, that's fine. And then they rent business premises, and they think, "Well, I just have to give 1 month's notice," and they go to give 1 month's notice to bring a 1-year lease to an end after a couple of months, and it turns out that there is no termination rights in a commercial lease. Okay. This is true. You can terminate a residential tenancy, but you cannot just say, "Oh, a couple of weeks' notice, and I'll terminate my commercial tenancy." So you're bound now for another 8 months or 9 months to this lease, paying $6,000 a month. Well, how do you get out of it? The courts have decided that you have to pay something like 6 months rent. Oh, whew. Instead of paying 9 times 6 is 54, I only have to pay 5 times 9, which is 45,000. Oh, well, that's easy. Okay, well, no, you can't afford that. So what you want to do is you want to put a termination clause in the agreement. This is true for all types of agreements. I had a client who had an operation in West Vancouver, and he made a product, really close to my heart. It related to beer, and I like beer. Nice, icy, cold beer is great. So what it was, I don't know this, when you go into a pub, or maybe you don't go into a pub, but if you did go into a pub, they have these big kegs of beer, and you have a draft beer. Okay, well, what makes the beer come out of the keg? It's because a line is hooked up to a can of, I think, CO2 gas, and the gas pushes the beer out. Well, as the gas pushes most of the beer out and it gets to the bottom, there's so much pressure from the gas that the beer foams, and it's really funny. Everybody laughs, and the poor bartender's covered with beer. And this is a problem because at the bottom of that barrel, there's a substantial amount of beer that they cannot get out. And so this is a cost to the business because they have to return the barrels to the beer supplier after paying for a whole barrel and not getting everything out of it. So my client developed a fob that they put on the line of the gas, which regulates the amount of gas so that it actually, you get almost all the beer out of the keg. And somebody had a patent on it, and he got the rights to the patent, but he had no money. And so he's making them in his garage in West Vancouver in a house that he rents. He's selling a few, and but he's making them, and he's going out and talking to people and trying to sell, and so he's not making a lot of money. One of the biggest beer distributors in the United States came to him and said, "I like your fob. What I'd like to be is your exclusive distributor for all of the United States." And my client went, "Oh, ching ching." He sees dollar signs, right? Because he thinks, wow, this guy will be able to sell thousands and thousands, and finally I'm going to make money on this. So he signs this contract. And then it turns out that this distributor is selling almost none of these. And this goes on, and it goes on, and it goes on. And of course, my client cannot sell in the United States because this fellow has the exclusive rights. But nothing is happening. So then he does some investigating, and he finds out that the United States distributor holds the exclusive rights to my client's product and also to a fob that doesn't infringe his patent, but so it's substantially different, and it's a company in Europe. And the profit margin on that one is way better than the profit margin on my clients. So what the distributor is doing is he's going into pubs and he's saying, okay, I've got this fob and I've got this fob. This one works better and it's a little more expensive, but I would recommend getting this one, not this one. And so the pubs are saying, okay, and they're buying the one where the profit margin is greater. And he's using my clients as a loss leader, basically. So my client calls me up and he says, I want to get out of this contract. So I said, well, what's the termination clause say? And he goes, well, there isn't one. And I went, oh, no termination clause. Oh, wow, then you have no rights to terminate. You're sort of, stuck with this contract for the rest of time. Oh, and I said, look, are there quota requirements? Like, does he have to sell so much per month and he's in breach of his quota? No, didn't put in a quota clause. And I said, okay, well, when did you sign this and how come you didn't let me have a look at it? And he said, he said it was such a great deal and I was so excited that I didn't bother coming in to see you. Well, it wasn't quite such a good deal. I might have missed the fact that there was no termination clause and I might have missed that there was no quota clause. The advantage for my client would be, though, I would be negligent and he'd be able to sue me for his loss. Whereas, number one, I probably wouldn't have missed it, okay? And then he would have a better deal. And number two, if I did miss it, then he could sue me. So a lawyer, what I'm driving at here, and I have nothing to gain by this because I'm no longer practicing, but what I'm driving at here is a lawyer is cheap insurance. You're less likely to have a problem, and if you do, and it's because the lawyer screwed up, then you get to sue the lawyer, and the lawyer has insurance. Okay, so it's in BADM 107. I always deal. I don't know about the other instructor, but I always deal with sort of 9 bullets of ideas out of an article from years ago. That's how to use your lawyer's time effectively, and one of those is how to get your lawyer on time. And I always tell my students that doesn't mean if you have a 2 o'clock appointment, get to the office 2 minutes before 2 o'clock or 5 minutes before your appointment. It doesn't mean that at all. What it means is don't sign the contract and then go to your lawyer. Okay, go to your lawyer before you make the deal. Get the advice up front. Okay, so just to complete that story, by the way, it was the U.S. multinational was a huge corporation, and we generated a great deal of anger and frustration with one of their people in their marketing department, and who is quite high up in the company, and we threatened to sue him for some problem, and he got really angry and he canceled the contract, and we said, oh, okay. And so my client got out of it sort of because they were so big they didn't know what they were doing. The left hand didn't know what the right hand was doing, sort of thing. So my client was very fortunate. But you want to look and think about having a termination clause in there. On slide number 99, I put one in out of a contract, and it says, unless sooner terminated under the provisions of this agreement, section 16, this agreement shall remain in force for an initial period of 1 year, and then after that, it can be terminated on 3 months' notice. That would be like a distribution contract where I'm going to start distributing your product. Well, you cannot tell me I have to do 100 a month. Why? Because I just got the product, I'm going to have to start introducing it to my clients, I'm going to have to get brand familiarity, I'm going to have to do some testing, some demonstrations. So the first few months I'm not going to be able to sell 100, okay? I may be able to sell, 5 and then 20, and then in the third month I can probably get up to, 40, and 6, 7 months I'm up to 90, and then, after a year I can sell 100 a month, but I cannot sell a certain amount right off the bat. So you you put in this 1 year clause, okay, because there's no way I'm going to pay you for the distribution rights and then have you terminate the contract before I've had enough time to actually get back my investment. So you put in this 1 year, and that gives the distributor a year to get up to speed, sell enough to get his investment back, and then start making a profit. And of course, you don't want to terminate the contract and lose a distributor. So this works in your favor. 1 year and then 3 years notice. After 1 year, he says, well, yeah, I'm managing to sell 100 of these a month, but this product just isn't as good as I thought it was, and I don't want to do this anymore. Then he can get 3 months notice and get out of the deal. If you said 100 a month and you've got a potential of selling way more than that, you might want to bring it to an end. So after 1 year, once he's made his money back, you can give him 3 months notice. Okay, that's one type, but you can draft a termination clause to fit your particular needs. Okay. Employment contracts, you should definitely have termination in there. If it is a sort of a line worker, you do have the Employment Standards Act that you can fall back on and say that after 5 years he's entitled to 5 weeks notice. After 7 years he's entitled to 7 weeks notice. But you can set some time limit. But if you've got a managerial client and they're entitled to basically 1 month per year of service, well, after the person's been with you 20 years, to get rid of that person is going to be really incredibly expensive, and that person is going to get a substantial windfall. So you may want to have a contract where you say, up to 5 years, you get 1 month per year of service, and then after 5 years, you get just 5 months notice, something like that. So you can take those things into account. While we're dealing with discharge by agreement, there are a couple of other situations where contracts can be discharged by agreement other than what we've discussed. And the first is a condition precedent. This happens all the time in real estate contracts. You want to buy a house, but you haven't found the house yet, so you do not want to get your mortgage yet, because if you get your mortgage, then you begin paying on your mortgage and you haven't found your house yet. Conversely, you don't want to find the house that you've always wanted and then not be able to get a mortgage, because then you've put a down payment down and you lose your deposit. So it's a bit of a catch-22 situation. And so in this situation, what you do is you put in a condition precedent. You say, here's $50,000 down payment. I want to sign an agreement to buy your house, and so both parties sign it. So this is a contract that isn't quite complete, but it does make it impossible for the vendor to sell the house out from under you. So the condition precedent has to be satisfied before the contract becomes final and binding. So what this means is, I say I put in this clause, and it'll be worded in such a way that I don't, I'm not, controlling everything. It'll say this contract is subject to, and they call them subject clauses in real estate contracts, but they're condition precedents. This contract is subject to my ability to get a Royal Bank mortgage on the property for 4% or less within 3 weeks. Okay? And you put that in there, and then you have 3 weeks to go out and shop and find your mortgage. And you've already done some work ahead of time, so you know that you should be able to qualify. Then you go out and get your mortgage. Once the mortgage is obtained, you haven't bought the house yet, okay, because closing is farther along. But once you've got the mortgage, then you take out that condition precedent. You say the condition precedent is discharged because it's been satisfied, and now the contract is final and binding, and eventually you tender the money and you get title of the property. Okay, so that protects the purchaser. But if you're in a market where the value of the houses are going up, you don't want to wait 3 weeks and then find out that the guy couldn't get a mortgage. Okay, or worse still, you're in a market where the prices are falling. Waiting 3 weeks, you're trying to sell it at $2 million. Well, no, he can't buy it, and so suddenly you have to list it again and find a buyer. And a month goes by, and the next thing you know, you cannot sell it at $2 million. You can only sell it at $1,750,000. Well, you don't want that, so you put in a condition precedent as well. So the buyer says, subject to my ability to get a mortgage, and the vendor says, okay, but if I get a better offer, then I will be able to give you 72 hours notice that you either take your clause out and make the contract final and binding, or I am released from the contract and I can sell to this other person. So you're going to buy a house for $2 million, and you're out shopping for the mortgage, and somebody else comes along and says, well, I'll pay you $2 million with no subject clauses. That's a better offer, okay? Because now the vendor can be assured that they're going to get the $2 million. So the vendor gives you the 72-hour notice, and then it's up to you to either say, let's gamble, I think I can get the mortgage, or say, okay, no, we don't want the house. So that's conditions precedent. They can be used in other types of contracts, but that's the best example. Conditions subsequence. You buy a ticket, and on there it says, on the back it says, to a hockey game, for example, it says, under certain circumstances they can cancel your rights under the ticket. Because let's say you're going to go watch the Canucks play, if we ever get out of COVID-19 again. But anyway, so you're going to go with a friend, and so you go up beforehand to the white spot, and you have a beer, and then you get to the rink early because you want to watch them warm up, and you have a beer, and then you grab one just before the first period, and then between the first period and second period, you grab another one, and then between the second period and the third period, you grab a beer and a hot dog, and by this time you've had so many beer that you're standing there with your buddies saying, go Lions, go Lions, go, because you're so drunk you think you're at a BC Lions football game, not a hockey game, and you're spilling beer on people, and you're being obnoxious. Oh yeah, you're a Rough Rider fan. Along come the custodians, and they take you and throw you out. Well, you spent I don't know what the tickets are now, but it's like $100 for a hockey game. You've got a contract to watch the hockey game. How can they just bring that contract to an end? It's because there's a condition subsequent in that contract which says an uncertain event that, if it happens, brings the promisor's liability to an end. Okay, you go to the P&E, Pacific National Exhibition, and they have venues. Song and dance and motorsports, all sorts of things, and they're not covered. And so if you buy a ticket and you go in and suddenly there's clouds in the sky and it starts raining, they're entitled to cancel those events. You do not get your money back. Okay, on the back of the ticket it says if for any reason any of the venues are canceled due to circumstances beyond their control, their obligation to provide that is at an end. It's like we went to Disneyland. Actually, from the time my first daughter was born until she was 10 years old, we went to Disneyland every year. We had friends in LA, and we'd drive down and go to Disneyland. We were there so often we had frequent visitor points. I'm just kidding, they don't have that. But anyway, we would go there, and I can remember when they brought out the Indiana Jones ride, and we were so excited. We went down and we went on the ride, and we thought, this is just an awesome ride. We went back the next year, can't wait to get on the Indiana Jones ride. We buy our ticket, get inside, open the program, and it's closed. We want our money back. Ain't going to happen, folks, because there's a condition subsequent in there. Okay, how are we doing? Discharged by frustration. we're not going to deal with this very much because we have the common law concept of discharging a contract by frustration. And it's sort of been overtaken and made less of a concern because the common law jurisdictions have adopted a civil law concept, okay? So the discharge of frustration is a situation where without the default of either party, okay, a contractual obligation has become incapable of being performed because the circumstances in which the performance is called for would render it radically different from that which was undertaken by the contract. So you have a trucking operation and you've got 18 trucks and they're out in your yard of your commercial premises, and you enter into this contract where you're going to carry gravel for the city and it's going to make you a fortune, and that night a meteor hits and destroys your trucks and you can no longer perform. And the city says, hey, you're under a contractual obligation to perform. I want you to be able to perform. Well, you could go out and you could buy 18 trucks. Pretty hard when you've just lost all that potential revenue. Or, well, you could rent them, but if you rented 18 trucks, suddenly your ability to do this contract would be substantially problematic because you're not going to make enough money to stay in business. So the contract would be frustrated. Okay, and there you can read the textbook if you want. I would recommend not bothering. Okay, like it's hard to get students to read the textbook anyway. But here's a situation where the law of frustration is so confusing, and it was so inequitable that people would have all sorts of problems. For example, we have a contract, and I am going to deliver product to you, and you're going to pay me on 30, 60, 90 days. So I deliver product, you wait 30 days, you haven't paid me. I deliver more product, you wait 30 days. And then there's a war, okay? And you're in another country than I am, and suddenly I cannot deliver any more product to you, and you haven't paid me. Well, this contract is discharged by frustration, which means you get to keep my product and I never get any money. That doesn't sound fair. Okay, so change it. I'm going to provide you a piece of equipment. I'm going to have to build it, but I'm not going to start building this unless you give me a down payment. So you pay me a down payment, I start building the piece of equipment, and there's a war. Okay, now I've got your down payment, but you haven't gotten anything. Too bad. It's discharged by frustration. And so we had these inequitable situations occurring. So British Columbia passed the Frustrated Contracts Act, which says things like, if I have received your deposit and I started building the equipment, then I have to give the deposit back to you, less the cost of my equipment. Unless, of course, I've already delivered something. So I'm building this huge piece of equipment and I send you some extra bolts. Okay, I've partly discharged it, so I get to keep your whole deposit. And so even the Frustrated Contracts Act in BC, which is a lot better than the common law, still had all these problems related to them. What lawyers do generally in a situation like this is they put in a force majeure clause, which is a civil law concept that common law has adopted. And I think on the next page, I've got a cartoon related to force majeure. It shows two lawyers walking out of what looks like a church. And one lawyer says to the other lawyer, "Do you believe in force majeure? Like, do you believe in God?" Which is supposed to be funny, but it's the best force majeure clause I could get and could find. Anyway, we adopt it, and the nice thing about force majeure is it doesn't cancel the contract. So the contract isn't void or discharged. The contract is suspended until such time as the person that was found it impossible to perform could perform. And here's a situation. I'm a supplier. Okay, so I bring in product from England, and I sell it to various distributors, and I have a contract with you to provide you this particular product, and this plant burns down, or there's a war, or like, who cares, but I cannot get the product. Okay, so you've already paid me a deposit, and I'm supposed to deliver the product, but the contract is frustrated. So I get to keep your deposit, and you get nothing, or whatever. It's going to be inequitable anyway. Well, a force majeure clause says the contract is suspended, not discharged, suspended. Okay, now until such time as I can find the product from another supplier and supply it. So I cannot supply it by the deadline, but I don't have to meet that deadline anymore. I can provide it later based on the force majeure clause, but eventually if I cannot get the product, then the one party can rescind the contract. But it allows a breather, okay. And what happens is, okay, I say, all right, I've got the situation where I cannot perform, but I've got 2 months to do so. Okay, so I'm going to try to get the product somewhere else, and it's a real problem for me because I'm not going to be able to get it at the price that I want it, so I'm going to make less money. So the buyer says, well, look, why don't we discharge it by waiver? You give me the deposit back, and I'll waive my contractual rights, and then you haven't suffered any loss because you don't have to buy the product somewhere else, and I can buy it somewhere else, and I haven't suffered any loss because I got my money back. So, okay, so through accord and satisfaction, or through waiver, you can resolve the contractual situation rather than declaring it void due to frustration. Or you can say, oh, okay, okay, you got 2 months, find the product. If you can find the product, fine. If not, at the end of the 2 months, give me my money back. Oh, okay, fine. And then you've got a potential for solutions to resolve the situation. The last thing I wanted to mention with respect to frustration, because quite often you don't have force majeure clause inserted into contracts, is that it cannot be self-induced frustration. If we go back to the definition of frustration, it is without default of either party, it becomes incapable of being performed. So if I have 18 trucks and I get a better deal somewhere else, or no, that's a bad example. If I have some trucks and I'm supposed to perform for you, but I find that I'm going to go bankrupt, it might be better for me to try to get the insurance on the truck. So I drive it off the road into the ditch, and I try to get the insurance from the insurance company, and I say to you, hey, I cannot perform our contract due to frustration because I don't have a truck. Well, this is what's called self-induced frustration, which means the frustrating event was caused by the party that's trying to get out of the contract. Again, self-induced frustration is something completely separate. One of the parties is trying to perpetrate a fraud, so that's. But we just say that in passing because it goes back and reinforces the concept of in frustration that it has to be an obligation that is outside, or the default has to be outside the control of the parties. All right, I'm going to take a short break here because I wanted to get the force majeure clause inserted into the lecture schedule, or lecture guide rather. All right, I've installed a force majeure clause so you can have a look at one. This is out of a distribution agreement, and the interesting thing about it is when you look at it, you can see that the concept from frustration of the inability of the parties to do the contract is also incorporated in it. It starts off, in the event of an inability or failure by the company to manufacture, supply, or ship their products because of all these reasons outside their reasonable control, then the company shall not be liable to the dealer during a period during the period and to the extent of such inability or failure. So you have a plant and there's a fire, and the plant isn't completely destroyed, but it's going to be a month or so before you can get up and running again. Then obviously your agreement is put on hold for that period of time. Okay, now to complete the concept of discharge of contracts, we have to look at discharge by operation of law, and we're going to look at two types. One is bankruptcy and insolvency. We have a Bankruptcy and Insolvency Act in British Columbia, or pardon me, in Canada, and what it says is that when you are bankrupt and a receiver is appointed, then all your assets belong to the receiver, and the receiver has control over it, which means that for a period of time you are incapable of entering into contracts for other than the necessaries of life. How a problem could crop up was I was involved in trying to prevent a delinquent person from getting out of bankruptcy their third time. And what had happened is the bankrupt had cashed in an insurance policy, taken the money, and put a down payment on a car, and was then making monthly payments. And I called the receiver on that, and before the judge in court, and the receiver didn't know this had happened, and the bankrupt person said, well, I needed a car, so I cashed in my insurance policy and used that down payment. And it was pointed out that the insurance policy wasn't his insurance policy. It was an insurance policy for the beneficiary, and therefore it was something that he should not have touched. The judge asked me what I wanted done in certain circumstances, and what I said was I wanted the money that was paid as a down payment to the car paid back into court. All the monies that were paid on a monthly basis on the loan paid back into court. I want the car returned to the car dealership, and I want that money then divided up amongst the rightful creditors, one of which was my client. The owner of the car lot came into court a week later and tried to oppose this cancellation of that contract. And the judge said no, that while he was in bankruptcy, he was unable to enter into contracts for non-necessaries of life. And you think, oh, well, transportation, a car, necessary. No, you can take taxis, you can ride a bike, you can take a bus or a sky train. So that was not considered a necessary of life. So the actual contract was canceled, discharged by operation of law, and the parties put back in the position they were in before the contract came into existence to the best of the court's ability. Well, that means the money was paid into court, and the owner got the car back. Incidentally, the owner of the car dealership was just enraged, and he said, how did I know that the person was bankrupt? And the judge pointed out that we have a bankruptcy registry. When somebody declares bankruptcy or is forced into bankruptcy, it's immediately updated, and if you contract with a bankrupt, you do so at your own peril. Okay, so that's one way that a contract can be discharged by operation of law pursuant to the Bankruptcy and Insolvency Act. The other one, the one that's really important to me right at this particular point in my life, is the Limitations Act. Okay, this says that there's a limit on the time period that someone has to sue you. And why is that particularly important to me? Well, I don't think that I've been negligent on any of my files, but it could be that I've made a mistake on one of my files and someone may want to sue me. And so do I live with the sword of Damocles hanging over my head for the rest of my life? No. With the installation of the new Limitations Act in 2012, it says that all contractual or all obligations are discharged after 15 years. So all my contractual obligations that I hadn't fulfilled. If there are any, you cannot sue me after 15 years, but more importantly, the Limitation Act says that after 15 years I can burn all my files because I can't be sued on any of them. So it's a very important statute for people that are ceasing to do business because they don't want things that happened many, many years ago to come back and haunt them. So you, under the the Limitations Act, it says you cannot be sued on a contractual obligation after 5 years. And I think I'm going to go in and check that to make sure I've got that right, because I might be thinking of the old statute. There used to be I think a 3-year term for torts and a 6-year term for contracts, and now it's sort of a standard 5-year term. So I'm just going to put you on hold for 1 second. I'm going to go into the statute. Okay, I'm glad I checked that. Apparently the standard, the general time limit is 2 years. So, but it's 2 years from the date that the problem is discovered. So if we have a contractual obligation and I somehow don't perform, and it takes you a while to find out that I haven't performed that. So let's say I've got, it's supposed to be completed within 2 years, but 2 years and 2 months, I find out, oh, wait a minute, he didn't do that. Well, you breached the contract, but the 2-year time limit is gone by. No, it doesn't run from the date the contract was entered into. It runs from the date that you discovered the problem. Okay, so 26 months later, you discover the problem. Well, you have 2 years from that date in which to commence your action. All obligations, though, do come to an end after 15 years for anything whatsoever. So if you had a 15-year contract and you've entered it here and you find out like 16 months later or 16 years later that there was a breach, well, you have 2 years from that date, right? But 15 years from the date that the tortious action takes place, for example, you find out in the 16th year, hey, wait, he was negligent. No, all claims are off. So any files over 15 years I can dispense with. All right, so that's how contracts can come to an end pursuant to the Limitations Act. Contractual obligations, okay. Those are the main ways that contracts can be discharged. And that will be all on this video. The next video will deal with estate planning as a risk management tool. We'll do that, and then we'll launch into the whole concept of real property. Thank you very much.